Good morning, everyone, and welcome to the last day of the 2022 ASPG conference. My name is Rachel Pineda-Lyon, and I am the newly appointed Secretary of the Victorian chapter of the ASPG. I hope that you found the sessions interesting and informative. I know for me, I've learned so much over the last 3 days. I'd like to begin by acknowledging the traditional Aboriginal owners of the lands upon which we are all zooming in from. I pay my respects to them, their culture, their elders past, present and future, and elders from other communities who might be here today. I'm speaking to you from Bluemmel in Naarm on Wurundjeri country. A couple of housekeeping things. Microphones are to be muted. Cameras off unless you're presenting or asking a question. And if you can save questions to the end of each session and use the raise hand function, or you can pop it into the Q&A box. Additionally, today's sessions will be recorded and made available to participants after the conference. So if you've got any issues or concerns about being recorded, please direct those to me via email. We've got a great session coming up. What I'll do now is I will hand over to Vaughn, who will be moderating our first session of the day. Vaughn, over to you.
Hello, everyone. Sorry, there's a bit of a delay there. I just had to be readmitted as a panelist. Welcome to the final day of the ASPG conference, and I'm very pleased, in fact, be introducing this last, or moderating this this morning session of the last day, when we have a very esteemed panel to present to us today. For those of you from Melbourne, I was listening to Sammy J the other morning on ABC radio when he's talking about what's the collective noun for a bunch of lighthouses, and people were nominating what they should be called, sort of like maybe you call it a constellation of lighthouses or an array. And I'm sort of reflecting on what do you call a collective noun for a whole lot of independent officers of Parliament, because each one of our presenters is an independent officer of the Parliament. So in keeping with the theme of the conference, perhaps you call it an illumination of independent officers, or depending on your perspective, maybe a spectre of independent officers of Parliament. But I'm sure we're all going to be illuminated by their presentations and the discussion that we will have today. Hopefully, so what I might do is I'll introduce each of the panel consecutively and offer a little bio before they begin, just a short 20-minute or so chat on what they would like to talk about today. And then after that, we'll just go into questions and answers. So our first panelist today is Mr. Sven Bluemmel, who's the Victorian Information Commissioner. Sven was appointed as the inaugural Victorian Information Commissioner in September 2017. Prior to his current role, Mr. Bluemmel served as Western Australian Information Commissioner for 8 years. Before 2009, Mr. Bluemmel held several senior positions in the Western Australian Public Sector Commission, the Department of Premier and Cabinet in WA, and the Commonwealth Attorney General's Department in Canberra. Mr. Bluemmel previously practiced law in the private sector in Melbourne and Perth, and in areas of information and privacy law. He is a regular contributor to Australian and international publications, particularly in the areas of information law, technology law, and administrative law. He has also delivered guest lectures at a number of universities. Mr. Bluemmel is a fellow of the Leadership Western Australia and served as president of the Institute of Public Administration in Western Australia for 3 years, from November 2014 until October 2017. He holds a Bachelor of Laws with honours and a Bachelor of Science, both from the Australian National University. It's very nice to meet you, Sven. And I might hand over to you then to perhaps talk a little bit about your role and what you want us to hear today.
Great. Thank you very much, Vaughn. I hope everyone can hear me. And for the questions that you put about Sammy J, I would say, how about an integrity of oversight commissioners? That would be my vote. As Vaughn's mentioned, I'm Sven Bluemmel. I'm Victoria's Information Commissioner. Thank you to the ASPG for the opportunity to be part of this panel. I'm really looking forward to it. I'm coming to you today from the traditional lands of the Bunurong people of the Kulin Nations, and like to pay my respects to their elders past and present, whose communities have cared for this country for thousands of generations. Now, my office is the primary independent regulator of information rights in Victoria, and we have combined oversight over information access, information privacy, and information security. And we do that under both the Freedom of Information Act 1982 and the Privacy and Data Protection Act 2014. What we aim to do is to build in the public sector a culture that promotes fair public access to information while ensuring its proper use and disclosure and protection. We also aim to build public trust in government's handling of information. And of course, the only way you can reliably build trust in such handling is if you handle information in a way that is actually trustworthy. Now, firstly, I'd like to touch on the content relating to transparency in the context of the work that my office does. Of course, I mentioned that we oversee the Freedom of Information Act, and in today's digital society, the public is more engaged than ever in matters of public interest and has higher expectations on government to be open and accountable. Now, one way this is reflected is in the constantly increasing number of FOI requests that agencies receive each year. To give an example, in the last completed financial year, 2020 to 2021, Victorian state and local government agencies received 42,249 formal FOI requests. Now, not only is that the highest number ever received in Victoria, it's more than any other jurisdiction, including the Commonwealth. Now, this is quite striking when you consider that the Commonwealth has responsibility for matters such as income tax, defence, migration, and social security. It's not necessarily a record that we want to have. We'd much rather see information being released more proactively without the need for so many FOI requests. Now, access to government information is clearly an important way for the community to understand government decisions and to actually participate in the democratic process. The public's right of access to government information and the corresponding obligation under the Act on Government Decision Makers to provide detailed reasons where access is refused is an essential mechanism for transparency and accountability. Also crucial is the requirement under the FOI Act for agencies to proactively publish certain information about their structure, functions, policies, and practices. Now, I'd strongly argue that the right to access information is necessary, absolutely necessary for a healthy democratic society. As I've already said, it facilitates public participation and enables public scrutiny of government processes, and all of that supports better decision making. It can help rebalance the power between government and the public, and it's also essential to enlivening meaningfully other human rights such as freedom of expression and freedom of thought. Now, of course, the law recognises the need to balance providing information to the public with protecting essential public and private interests. And of course, for this reason, there are limited exceptions and exemptions to the legislative right of access. But importantly, it was Parliament's intention that the provisions of the FOI be interpreted in a way that gives as much access to government-held information as possible, as quickly and as cheaply as that can be done. I must say that this is not always the way the Act is interpreted by government. My colleagues and I are working very hard to change that, but we are under no illusion of the immensity of the task. And as part of that work, I strongly advocate for agencies to release information proactively and informally wherever possible, as opposed to waiting for an FOI request. And when dealing with an FOI request, I advocate for agencies not taking an overly technical approach to the application of exemptions or exceptions. So that leads me on to some of the work that my office has been doing to enhance access to information in Victoria. Since 2019, when the office has started doing some serious research in this space, we've undertaken a couple of big projects to better understand the FOI culture in Victoria. Now, the overarching aim of these projects is to develop strategies to shift the information access culture to be open by design, and to improve and expand access to information through proactive and informal release of information. As I've already said, agencies need not wait for a formal request for information under the FOI Act before assessing whether information is suitable for release. We do acknowledge that there are very real challenges facing administrators in the FOI space, including limited resourcing to process requests, the consistently growing FOI demand, both in terms of volume and complexity, and legislative limitations which contribute to delays in decision-making. Now, unsurprisingly, these challenges were exacerbated by the COVID-19 pandemic. Just this week, my office released a special report looking at the state of FOI in Victoria from 2019 to 2021. My report focused on the impact that the pandemic has had on administering the Act, and I'm pleased to say that the report appears to have struck a chord. Now, the pandemic, perhaps not surprisingly, has resulted in further delays in processing FOI requests, delays in decision-making and timeliness, and stronger reliance by agencies on the use of exceptions to refuse FOI requests categorically. And these are concerning trends. I've also caused a report to be tabled in the Parliament last year that looked at the causes of delay across the sector, and one of the recommendations from those was that our Act really needs to be modernised. And again this week I've highlighted that transparency in Victoria would benefit from a well-considered and comprehensive review of the Act to bring it more in line with modern notions of government transparency, accountability, and the way government works in the digital age. But equally as important as legislative review to improving the access regime is cultural change. And proactive and informal release is instrumental to this. Now, under the FOI professional standards, which my office developed to help agencies administer the Act consistently with its object and Parliament's intention, agencies are required to consider whether documents requested under the Act can be released informally outside of the confines of the Act. And this is intended to influence agencies to consider proactive and informal release in the first instance, making FOI effectively a last resort. Now, proactive and informal release can make it easier for the public to access information and more efficient for agencies to facilitate access to information and thereby reducing the burden on them. Not only does that improve service delivery, it also helps to build trust and confidence. Now, my office is undertaking a program of work to help shift the FOI culture in Victoria to be open by design. A range of measures will be implemented over the next 12 to 18 months and beyond, broadly focusing on education and training, stakeholder engagement, and promotion of proactive and informal release. And I'd like to briefly touch on the relationship between transparency on the one hand and the protection of personal information through privacy laws on the other, because these two concepts can sometimes be seen as being at odds with each other. Although I must say that in practice, as the regulator regulating both, it's actually quite rare that the two are directly in conflict. Now, government, of course, collects significant amounts of information from the public to deliver services, develop solutions to public issues, and to even innovate. Information is now more important than ever, especially as government becomes increasingly digital to keep up with technological advancements and the digital age. It's therefore essential that government ensures it adopts privacy practices that properly protect the information it holds and meets community expectations. Doing so will build the public's confidence in government's ability to handle personal information appropriately, and it will also increase the public's willingness to engage meaningfully with government. Now, the minimum standards for good privacy practice are set out in the Information Privacy Principles in the Privacy and Data Protection Act. They include limiting the amount of personal information collected to what is necessary for a specified purpose, and that reduces the risks associated with over-collection and overuse of personal information. Now, relevantly, good privacy practice also includes being transparent about information handling practices in the first place. Clearly written, accessible privacy policies and collection notices are crucial to transparency. Not only should public sector organisations have privacy policies that broadly set out how they manage personal information, but privacy law also requires organisations to provide collection notices setting out very specific matters related to that particular collection and the subsequent use and disclosure. Now, transparency about these information handling practices promotes respect for individuals' privacy rights, as it allows those individuals, in most cases, to make informed decisions about their personal information and to exercise greater control over it. Let's not forget that respect for privacy is a fundamental human right. Now, this is important considering in many circumstances, the public, when dealing with government, effectively has no choice but to provide some personal information to access services. Now, think about the last 2 years and the information we've had to provide, checking into venues, getting a PCR test, revealing details of close contacts. While all of these involve unprecedented collection, use, and disclosure of personal information, citizens can at least be secure in the knowledge that this collection, use, and disclosure was governed by legislative privacy protections overseen by an independent regulator who reports to the Parliament. And as that regulator, I am generally pleased to see that government has overall respected the importance of such protections, not just because there is a legal obligation to do so, but even more importantly, because such respect actually leads to greater trust, and that leads to better public health outcomes. Now, I want to finish my opening remarks with a defense of some aspects of our system of oversight that are not often celebrated, namely tension, ambiguity, and messiness. Now, as Information Commissioner, I was particularly interested in hearing from Jonathan King, Deputy Clerk of Tynwald and Clerk of the Legislative Council of the Isle of Man, in yesterday's session on parliamentary privilege and procedure. You'll recall that Jonathan outlined the interaction between the Information Commissioner on the Isle of Man and its Parliament. You might also recall that that interaction was, shall we say, not uncontroversial. Those of you from the Victorian Parliament will have been relieved to hear from Bridget Noonan that the distinction in Victoria is rather more clear, and I expect that the chances of Bridget and I having a similarly fundamental disagreement to that experienced by Jonathan and my counterpart on the Isle of Man are rather low. But at its core, the story illustrates a really important issue, and it reminded me of a matter that came before me when I was the Western Australian Information Commissioner. An opposition member of Parliament, who is now a minister, made an FOI application for documents that included contentious issues briefing notes to the then Minister for Transport. These were prepared by public servants to brief the Minister in relation to expected questions to be asked in Parliament in relation to a contentious project. In light of the wording of the relevant exemption under the Western Australian FOI Act, I ultimately had to decide whether disclosure of such documents would infringe the privileges of Parliament. Now, given my personal interest in such matters, as demonstrated by my long-term involvement in the Australian Institute of Admin Law, the Australasian Study of Parliament Group, and the Institute of Public Administration Australia, I couldn't believe my luck. But as is so often the case in these matters, the term "the privileges of Parliament" was not defined in the Act. I had to go back to the Parliamentary Privileges Act of 1891 and the WA Constitution Act of 1889, and surely these would settle the matter. But alas, no. Instead, those instruments effectively imported the privileges enjoyed by the House of Commons in the UK. And ultimately, I found myself digging through the UK Bill of Rights of 1688. I suspect that today is one of those really rare occasions where I'm not the only person in the room to have done so. Now, to cut a long story slightly less short, Article 9 of the bill states that, quote, "the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament." Now, on the particular facts of the case, I found that the documents in question were indeed prepared for the purposes of, or incidental to, the transacting of parliamentary business, and also that their public disclosure would infringe the privileges of Parliament because Parliament had not authorised such disclosure. Consequently, disclosure would encroach or trespass or infringe upon Parliament's power to control the publication of documents and information incidental to its business. Accordingly, my review decision held the documents to be exempt. Now, why am I telling this story today? I'm telling it because it's an illustration of the fact that our system, inherited from the UK and much customised and further evolved, is not free from ambiguity. It is not free from tension between the three arms of government, and it's of course not even free from tension within any one of those three arms. And as I'm sure all three of us on this panel can personally attest, it can be messy. Now, none of this is to say that we should not seek to improve clarity, remove some ambiguity, and make calm, informed decisions about addressing undesirable and destabilizing tension where that is possible. But we should also not expect that the best possible system will have no ambiguity, no tension, and no messiness. I can think of several countries where there is absolutely no ambiguity about the relationship between the executive, the legislature, and the judiciary, but I probably wouldn't want to live there. Thank you.
Thank you so much, Sven. That was really, and I'm glad you were able to listen to Jonathan King's presentation yesterday, because when I was listening to it, I was thinking, how can I work this into the Victorian Information Commissioner session tomorrow? But fantastic. And yes, I mean, I guess even from the clerk's perspective in Parliament, yeah, tension, ambiguity, and messiness is pretty much every sitting day for us as well. But thank you very much. Next, I'd like to introduce the Ombudsman in Victoria, Deborah Glass. Deborah Glass was appointed as Victorian Ombudsman for a 10-year term in March 2014. Her office looks at the decisions and actions of Victorian government departments, local councils, statutory bodies and their contractors. Deborah was raised in Melbourne. She practiced law briefly before leaving Australia, working for an investment bank in Switzerland before moving into a career in financial services regulation in Hong Kong and London. She then became a commissioner of the Independent Police Complaints Commission of England in Wales, heading up criminal and misconduct investigations into police. In 2008, Deborah was appointed IPCC Deputy Chair, and in 2012 was awarded an OBE for her service. Deborah is on the board of the International Ombudsman Institute, which connects more than 190 ombudsman offices worldwide. I'm very pleased to have Deborah present as well this morning, and I can see that their presentation is already up, so I'll hand over to you, Deborah. Thank you very much.
Thank you very much, Vaughn, and let me acknowledge as well that I join you here from Bluemmel country, and add my own acknowledgement that that country always was and always will be Aboriginal land. It has never been ceded. I wish we were present today in Naarm. I wish we were present in Parliament House, in fact, because I'm a bit over these Zoom conferences, I have to say, and screen sharing, and I would much rather be talking to a real live audience, especially as I cannot see a single one of those I'm presenting to. But there we are. If I can just pitch in with your first question, the collective noun for ombudsman is something that has been a matter of considerable discussion in the ombudsman community, and I think probably the two winners are, depending on your perspective, a grievance of ombudsman or an oracle of ombudsman. So I will perhaps let the audience decide which of those they prefer. But look, what I want to do today in the time allocated is talk about integrity and oversight during a pandemic, through the lens of my office. And if I could see any of my audience, I would be asking you the question, what do you know about the role of my office? So I'm just going to have to assume from the nature of members of the ASPG that you do know what an ombudsman does, and I don't need to give you that kind of background. I'm a constitutionally independent officer of Victorian Parliament, and I investigate complaints and systemic issues, and I'm Parliament's investigator. I'm effectively a standing royal commission with additional sort of creative powers to resolve complaints informally and improve public administration. So I'm not going to talk more about the role of the office. I'm assuming everybody is sufficiently familiar with it. But my remarks about the last couple of years, I hope, will help to illustrate the sort of thing that Parliament's investigator, that Parliament's Standing Royal Commission can in fact do. Because the pandemic has obviously impacted us in all kinds of different and significant ways. I mean, let's face it, in the last couple of years, it's totally changed how government services are provided to the community. The public service moved online, no more face-to-face contact, interstate borders were closed, and I think really significantly for many people, hotels and our own homes became places of detention. And of course, to protect public health and well-being, but the impact that had on human rights and the impact that had on the discussion about human rights, I think was really significant. So let's have a look at Oh, if I can get this thing to move. Would you like to do that? So this is always what happens with the technology. You think you're doing really brilliantly, and it doesn't actually move. Ah, here it does. Right. So this is the COVID timeline is going to be obvious to anybody, but let's a little reminder of the last couple of years, which for many people are a complete blur. We had our first recorded case in late January 2020, and by March of 2020, I think almost every state and territory had declared a state of emergency in some manner or form and invoked emergency public health powers. Now in Victoria, this came from the Public Health and Wellbeing Act, which allows the Chief Health Officer or their delegates to issue directions to detain people, restrict movement, and so on. And I point out that the Chief Health Officer and their deputies are health bureaucrats, and they're within my jurisdiction. So what we saw throughout March is the exercise of emergency powers to restrict gatherings and so on and so forth. And we've had stay-at-home orders, and restrictions on the whole then began to relax in about May, when we thought it was all over then, didn't we? But in July, of course, things changed, and this is widely referred to as Victoria's second wave. Now, what significantly happened then, and everybody in Victoria will be aware of this, and I think most people around the world, in fact, indeed, were aware of it, because it made headlines everywhere, that on the 4th of July 2020, about 3,000 residents of 9 inner Melbourne public housing towers were detained by the state, and they received no notice or explanation to stay in their often crowded homes. And we saw images of their distress sort of flashing in television screens around the world. And here is just a little bit of an illustration for you. So I investigated the detention and treatment of public housing residents arising from this lockdown. And what I found in this investigation is that around about 11 o'clock in the morning on the 4th of July, we had senior officials dealing with the emergency agreed that an intervention was necessary. You know, cases were rising, it was clearly important. They discussed a structure, including the need for community engagement and security and so on. And they told us in our investigation that they expected the intervention would not begin until midnight the following day, which is about 36 hours away. But what happened, of course, memorably, is that at 4:08 p.m. on that day, the Premier announced the lockdown effective immediately. And most people found out about it when they saw police officers outside their homes, surrounding the blocks. The Deputy Chief Health Officer, who was the expert on the day, acting as the Chief Health Officer, told us that although she signed the directions, the timing was not in her advice. She was given less than 15 minutes to consider the implications of several lengthy documents and their human rights implications. So on the evidence available to me, which did not include cabinet and confidence documents, the decision to bring forward the operation was traceable to a cabinet meeting earlier that afternoon. And despite the best efforts of people on the ground, who I did not criticise, it was completely chaotic. People found themselves without food, medication, essential supports, baby supplies, and so on. Information was confused, incomprehensible, or simply lacking. And on the ground, nobody seemed to know who was in charge. No access to fresh air and outdoor exercise was provided for over a week. And in a particularly unfortunate act, temporary fencing for an exercise area was erected one night and surrounded by police. And although it was quickly taken down, it reinforced people's sense that they had been imprisoned. So after 5 days, the lockdown was lifted on 8 of the towers, but it remained in place for one tower for a further 9 days. Now, it worked, it did halt the spread of COVID in the building, but in my opinion, and this was my finding in the case, the detention of residents without notice appeared to be contrary to law, and I was specifically referring to a breach of the Charter of Human Rights, because it was not taken on public health advice. Although it was intended to be taken, it wasn't intended to be taken immediately. And the base, given the foreseeability of the consequences, I wasn't persuaded that it was compatible with their human rights, including the right to humane treatment when deprived of liberty. Now, not perhaps altogether surprisingly, the government did not agree with me that the detention of people was contrary to law or their human rights were breached. Now, I'm not a court, and only a court can determine questions of lawfulness, but I can express an opinion based on the evidence gathered, and that is what I did. There were documents relating to the lockdown asserting there were security concerns, suggesting that they were a hotbed of criminality and non-compliance, but in fact, the evidence was that they were vast majority of law-abiding citizens, just, or not citizens, just like other Australians. I didn't criticise the Deputy Chief Health Officer, who was in an impossible situation, or the many hundreds of public officials dealing with the crisis. And I said in my report that while they may be tempted during a crisis to view human rights as expendable in the pursuit of saving human lives, this thinking can lead to dangerous territory. It's not unlawful to curtail fundamental rights and freedoms where there are compelling reasons to do so. Human rights are intrinsically and fundamentally involve the consideration of human lives. And I said the government need make no apology for taking action to keep us safe. But the decision to bring forward the operation to detain 3,000 people immediately did not appear to be based on such advice. So I recommended that the government apologise publicly to those detained at the towers for the harm and distress caused by the immediacy of their lockdown. And this is one of the very few of the recommendations I've made in the 8 years I've been in the role so far that was not accepted. Now, while they didn't actually accept my recommendation, what I did think was quite interesting was that when a year later, almost the same situation presented itself in the public housing towers, the response was very different. And I did observe that actions do indeed speak louder than words. So that was July of 2020. We all, I think we all remember the sigh of relief we all breathed at the end of 2020 when we thought it was all over. And of course it wasn't. And what happened then, of course, was that we began to see the third waves and the fourth waves. And now we get to the closure of borders. So back in January of 21, we had a traffic light system for interstate travel, and in March of 21, as case numbers elsewhere were beginning to rise, that kept being updated. So we began getting used to lockdown, but of course the Delta variant then takes hold in New South Wales and the ACT, and we began seeing people being locked out. So travel was inconvenient at the time, it was actively discouraged, but it wasn't actually impossible. And what was happening by about July 2021, when the New South Wales was declared an extreme risk zone, is that the borders then shut in a way that few people could ever have contemplated. People were given 12 hours to cross the border or else, and that was impossible for many people. So when this was announced in July, the Premier stated that this was all going to be difficult, there would be exemptions on compassionate grounds. And he went on to talk in some detail about, we had to be patient and it was going to be difficult, but it would happen. So here we are in the middle of 2021. Our borders are shut as they have not been for 100 years. And very quickly, and not perhaps surprisingly, we began getting complaints. People were telling us that, despite this exemption scheme that the Premier had promised, they weren't able to get exemptions to farewell loved ones at funerals and attend vital medical appointments or care for their family members and so on. And people found themselves effectively homeless and caught up in a bureaucratic nightmare. So one example that really, and there were many horrendous examples included in the report, but one that really stood out for me was a complainant who was trying to get home to her terminally ill sister, who was being cared for by their elderly mother, who was asked for evidence of her sister's cancer diagnosis, her treatment and life expectancy, her birth, marriage, divorce certificates and her driver's license, and a statutory declaration from her elderly mother. Now, this is somebody camped on the other side of the border without access to documents, in some cases, internet facilities, who's being asked to provide an absurd amount of documentation. to support what was so plainly a compassionate request. And what we knew from our investigation is that in those first few months after the exemption scheme came into effect, the Department of Health received over 33,000 applications, which they granted 8%. Now, the overwhelming majority weren't actually rejected, but they were closed for other reasons. And people simply weren't given reasons for the refusals, and they weren't given an avenue of appeal. And one of the things I said when I put the report out is that, aside from the myriad cases that should have been cause for compassion, what we were also seeing is that case numbers were rising in Victoria. You can understand the reasons for caution, but they're by the stage that we were seeing around about September, people were still being refused exemptions, even when there were more cases in Victoria than on the other side of the border. So there was, what that was saying to me, that was this narrow exercise of discretion, which might have been justified at a certain point, simply persisted well after an elimination strategy had been abandoned. And it was really hard to figure out how fully vaccinated Victorians just trying to get home and willing to isolate were still being stopped at the border. So I put out, yet another of the Ombudsman's famously critical reports in December of last year, and you can see here a few of the headlines. But one of the points I wanted to make with that is that while the circumstances may seem to be unique, and may they never happen again, at its core, this investigation was about something very common: poor administrative decision-making. Failure to exercise discretion, not giving reasons for decisions, failing to offer a right to review, these can all damage public trust in those who make decisions and ultimately in government. So moving on to my third example and final example for today, I'm here we now at the end of 2021, we're getting closer, folks. I'm preparing to table my border investigation report, which is my third major COVID investigation. And what we find is that Parliament is debating amendments to the Public Health and Wellbeing Act, and people are now protesting on Parliament's doorstep. You might recall some of this. So I've made recommendations in my tower lockdown investigation to amend the Public Health and Wellbeing Act to provide greater safeguards to people detained. So, there's a lot of it was hugely controversial. The scenes were memorable. And in the course of this, and I didn't expect to be involved in it, I was asked, what do you think of these new pandemic bill, these new powers? And I expressed the view that I think anybody would express from an ombudsman, namely that significant powers, such as those in our public health laws, need significant oversight. And I pointed out that it was not in that from a bureaucrat, the chief health officer, to a minister, but I pointed out that meant that something was going from my jurisdiction to something outside my jurisdiction, which again, no problem, but where's the oversight? It doesn't have to be me, but there does need to be independent oversight. I didn't think that was a particularly controversial view that I was expressing, but it made the front page of The Age, and it made significant headlines around the time. And what it did do was to provoke some really quite interesting and constructive engagement with relevant lawmakers. So it's nice to be relevant, I have to say, and that's essentially what happened around the pandemic debate, because the bill that was ultimately passed was vastly improved on the initial version that was introduced into Parliament. And as I said, it changed the key decision maker to the minister, but it added in a mechanism for parliamentary oversight, which was significantly better, and other forms of oversight, including in detention, that it was significantly better than had been originally proposed. And of course, as a committee of Parliament, this new Pandemic Declaration Accountability and Oversight Committee, this new body also has the ability to refer any matter to me as Parliament's investigator for investigation. So let me stop at that point. As we've seen through the pandemic, human rights are not absolute. We've all seen our rights and freedoms being taken away, and those rights being curtailed for reasons most of us did not question. And my office has not investigated every COVID-related complaint we received, and I've received a lot. We received huge numbers of complaints about vaccine mandates and mask wearing, which were, I have to say, promptly responded to and appropriately closed. But I hope the matters that we did investigate demonstrate the importance of independent oversight, particularly during a crisis. And I hope that also gives you some sense of how independent oversight and scrutiny do operate in the exceptionally challenging few years that we have all been through. Thank you very much.
Thank you very much, Ombudsman. There's a lot of content there, and I'm sure there'll be questions about that at the end of the session. I would just remind everyone, if you do have questions that you'd like to raise, you can raise them in the Q&A tab at the bottom of your Zoom screen there, or of course, when we reach that part, if you have a question, you can raise your virtual hand and we'll call on you. I will now introduce our final panelist, the Honourable Robert Redlich, AMQC, who's the Commissioner of the Independent Broad-Based Anti-Corruption Commission, or IBAC in short, is what we call it here in Victoria. IBAC's Commissioner is an independent officer of the Parliament and is responsible for IBAC's strategic leadership. The Honourable Robert Redlich, AMQC, commenced a 5-year term as IBAC Commissioner on the 1st of January 2018. Commissioner Redlich was a judge of the Supreme Court of Victoria for 15 years, including 11 years as a Victorian Court of Appeal judge. He was previously a member of the Victorian Bar for some 30 years and served for a period as chairman of the Victorian Bar Council. His significant achievements in legal practice were recognised with his appointment as a Queen's Counsel in 1984. Commissioner Redlich brings extensive experience to IBAC, including the investigation of corrupt practices within the public service and the police. He has successfully prosecuted and defended cases involving corrupt practices, and I'm very much looking forward to hearing your contribution today, Commissioner.
Thank you very much, Vaughn. I commence by also acknowledging the traditional owners of the various lands upon which we are gathered today. So despite this being the 5th day of my quarantine, as I have tested positive to COVID, I'm delighted to be able to speak to you about the conference topic of parliamentary transparency, checks and balances. And it provides me with a special opportunity to avoid discussion on the range of functions of the Integrity Commission and rather explore with you the current issues that we are seeing permeate through executive government. And when I say executive government, I mean ministers, their advisors, and the public sector. These are issues which need to become a matter of intense public and parliamentary focus throughout the country. The unprecedented challenges of the COVID global pandemic, some of which have been touched on by my colleagues, has brought into sharper focus the importance of integrity within executive government. Now more than ever, a parliament in exercising its legislative powers in this rapidly changing environment needs confidence that the executive government will provide it with the transparency and accountability in its decision-making processes. That being something that's essential if members of Parliament are to be best placed to serve the public interest. Now, for there to be true transparency and accountability within the parliamentary process, there must be transparency and accountability within the executive government. After all, it's the executive that brings its decisions to Parliament and generates most of the work of the Parliament. I want to focus on 4 features of executive government that are now very apparent at a federal and an interstate level and throughout most of the country. These are features which I suspect touch the work of all of you present today. So it's emerged over perhaps as long as the last 4 decades that there's been an increasing shift in the balance of power within executive government at state and federal levels. My observation today is that it has now become a profound and endemic problem in the way in which government works, which is inextricably affecting the level of transparency of members of parliament in discharging their parliamentary role. There are 4 recurring themes that are startlingly clear. Could you put up slide 2, please? So those 4 themes are the centralisation of power within executive government, the transference of power to ministerial advisors, the diminution in influence and accountability of ministers in their own portfolios, and the diminishing role and influence of the public sector. So let me say a little bit about each of these and commence by making the point to you that the days of yes minister are long gone. It's no longer the heads of department who are the driving force of executive government decision-making, nor, unfortunately, is it too often the individual ministers who are giving voice to their oath that they make decisions without fear and favour. These themes that I want to explore with respect to executive government landscape should not startle any of us. These are now observations which have been repeatedly expressed about the federal political landscape and the state of executive government in reports of interstate integrity commissions, parliamentary committees, commissioners' reports, and in academic writings. Let me just mention some of them briefly because they reflect the experiences of my commission in the work that it is doing. For example, the Grattan Institute report of 2021, titled Gridlock, Removing Barriers to Reform, notes that the career prospects of today's politicians and their advisors motivates them to pursue politically expedient policies. It refers to the growing number and power of ministerial advisors, the weakening of the public service, which has made it harder to pursue reform. It notes that often the public service is not asked to provide advice or is not capable of providing it and is overly pliable in serving the political interests of the government of the day. Excuse me. Also, at the Commonwealth level, the Fodey review commissioned by the federal government in 2019 highlighted the need for better frameworks to ensure a clear understanding of the respective roles of ministers, their advisors, and the public service. The review found widespread concern that public service capability has declined, particularly through the hollowing out of strategic policy skills. It's irresistible that I make reference to the Senate Select Committee, which dealt with the Children Overboard inquiry now more than 20 years ago. They made some extraordinary findings about the federal state of play, some of which are worthy of reminder. The number of staff working in ministers' offices, which even at that time had doubled over the last 20 years. The committee's inquiry highlighted the serious accountability vacuum at the level of minister's office. It noted that the function of the evolution of the role of advisors was such that they now enjoyed a level of autonomous executive authority. Such advisors were not required to account for their actions directly to Parliament, nor were they accountable in appearance before parliamentary committees. The committee noted that it is no longer a legitimate assumption to make that ministerial advisors act at the direction of ministers and/or act with the knowledge and consent of their ministers. Now remember, this is all 20 years ago. And let me say to you that things have got far worse since then. Ministerial advisors, they found, seem to be willing and able to act on their own initiative and to intervene in public administration and to take decisions affecting performance of agencies. They noted that ministers tend to recruit onto their personal staff hand-picked groups, most of whom share the minister's political outlook and have strong commitments to ensuring that their minister is effective in both the party room and parliament. And as their numbers and perceived influence grew, the Select Committee noted that ministerial advisors do not, like the public servants that they've succeeded, act as a political buffer, limiting the risk of politically partisan activity in the public service. They are increasingly interventionist. They embroil agencies improperly as means to achieving politically partisan ends. Now, that was 20 years ago. Let me take you to a report that's only a month old. And I speak now of the interim report of the report commissioned by the Queensland Government, an interim report of Peter Coldrake, who was asked to examine the culture and accountability of the Queensland public sector. He noted the role of the public sector in most generations had been weakened by the rising influence of ministerial office. He noted now the widespread use of external consultants. He noted in particular that there's been a perceived overreach of ministerial staff and that there had been a decline in the proper management of the interface between ministerial officers and departmental staff. And so they are but a few of the reports and insights that one could gain if one were to want to explore this issue. Most recently, in the scholarly work of Yi Fu Nguyen, she noted in addressing the rise of ministerial advisors that it shows that throughout Australia there's been a fundamental shift in the locus of power from neutral public service to highly political and partisan ministerial advisors. And she demonstrates in her book that the introduction of ministerial advisors into the structure of the executive has led, she puts it as highly as this, has led to the erosion of the Australian system of responsible government as we know it. Now, let me say something about the centralisation of power and influence. A common feature at a federal and at a state level, and Victoria is an example, is that leaders of government have an ever-burgeoning number of advisors who in turn exert influence over each individual minister's advisors. The tentacles of pervasive influence extend into the public service. Their influence risks undermining the independence and authority of each individual minister. That feature, the centralisation of power, has made a substantial contribution to the form of executive government landscape as we know it. All of these features resonate with the experience and learnings of my commission. When looking at the checks and balances which the topic today raises that would aid transparency in Parliament, one cannot, of course, avoid making an albeit a very brief observation about the change in role of the news media, where objective analysis has given way to the proliferation of commentators, most of whom regrettably write from an entrenched, politically biased perspective. And as the Grattan Institute's most recent paper noted, a number of these media trends have made it very difficult to propose for government to propose an unpopular policy and much harder to lead a public conversation about why an unpopular policy is nevertheless in the public interest. So these repeated and recurring observations about the executive government landscape throughout the country inevitably affect the transparency and accountability of executive government. They pose integrity risks and they affect the dissemination of important information within the parliamentary process. Those features of executive government landscape give rise to the traditional safeguards that exist being ignored. They increase the risk that decision-making occurs outside of the forums that have been specifically designed to ensure transparency and accountability. The consequence of these features then is the erosion in the accountability of executive government. The risks significantly increase that decisions are then being made to meet the needs of people and institutions with a vested interest, and not always because they serve the best interests of the broader community. Ultimately, it then impacts directly on the level of transparency and accountability within Parliament. Now, most of you will, I suspect, better understand than I the multitude of ways in which Parliament can be informed about matters relevant to legislation that they are required to consider. The introductory speeches of ministers, inquiries by parliamentary committees, question time, debates, they are only some of the ways transparency and hence accountability can occur. And where that transparency and accountability is lacking at the executive government level, it's not going to find its way into transparency within the parliamentary process. So drawing upon those common experiences, one can make a number of broad and valid general observations. The role of ministerial advisors has undoubtedly grown enormously. Their sphere of influence has now developed with a corresponding significant weakness in the public service. Advisors generally have strong party affiliations. Too often they have little experience in the public service, but they come to their job with aspirations for pre-selection or for a career in various forms of government advocacy. Remember that advisors' original role was to bring a political and strategic lens to policy questions which were being furnished to the minister by their department. Now, that role of ministerial advisors has continued, that is, to bring that political and strategic lens, but whilst the purpose remains, their sphere of influence in discharging that function has so greatly expanded, with the most serious and obvious consequences for the public sector. Coldrake, in his report, examples advisors improperly influencing public sector employees, resulting in the inevitable bypassing of departmental processes which are designed to ensure transparency and accountability. In doing so, ministers can show plausible deniability of the conduct, claiming they're not aware of their advisor's conduct. And we would have seen graphic example of that in the inquiry, the quarantine inquiry, which recently concluded in Victoria. Well, that takes me to the question of the Westminster Convention about the responsibility of ministers for their portfolio department. There are differing views amongst academics about whether or not the convention still applies with the same force. But my observation is that someone outside the department has to be responsible and accountable for the work and the decision-making of the department. The role of the public service is plainly enough critical to the need for executive government to behave with transparency and accountability. There's too often been concern that senior executives in the public service will do what they perceive their minister wants them to. And they do so out of fear or reluctance. That the notion of frank and fearless advice from public servants has fallen into disuse. We have become desensitised to the extent to which senior officers in government departments are expected to support the political and strategic direction of the government of the day. Why? And what's the most glaring example? It's because it's become commonplace to talk about the fact that when a new government is elected, there is immediately a change of leadership in so many of the senior positions in the departments which are required to support the ministers of the day. It is a disturbing environment. There is a grave need to address the trends that we are seeing. And you, of course, are going to be best placed as you move forward in your careers to achieve those objectives. To achieve them, there needs to be clear standards in place. Could you put up the next slide, please? To achieve those standards, there needs to be effective controls and cultural alignment. These are all principles with which you would be familiar. Now, this is not the occasion to explore the extensive reforms that are necessary in order to restore confidence in the manner in which executive government operates. But I'll mention only one, which is a primary change that's critical if we're to arrest the slide in transparency and accountability of executive government. A primary check or balance to ensure parliamentary transparency can be linked to there being a poor code of conduct which is not fit for purpose for ministerial advisors. In most places, that code is not enshrined in legislation, and there are no sanctions applicable to the ministerial advisor who departs from the code of conduct. The Fodey Review and the Grattan Report both suggest that critical reforms regarding ministerial advisors are necessary. There must be a code which is legislated and enforceable. That has yet to occur in most jurisdictions. So may I conclude by saying to you, these present features of executive government exist, and transparency and accountability will continue to decline until those trends are arrested. This calls for a willingness by members of Parliament to demand maintenance of the fundamentals of the Westminster system and its conventions, that ministers discharge their roles without fear or favour, served by advisors who are accountable for their conduct and for whom the minister is responsible, and served by departmental officers who are impartial and who are able to provide frank and fearless advice on policy. Only then will public trust be restored and parliamentary transparency in the decision-making of executive government properly advanced. Thank you for listening.
Well, thank you, Commissioner or Commissioners and Ombudsman. Big issues there and really substantial things to discuss. We have a couple of questions there, but I might get in first. In particular, sort of reflecting on the roles of ministerial advisors, they occupy an ambiguous space in Parliament, as well as you've identified, you know, for example, if it's difficult to interrogate the decisions, you know, if you want to look at that, you know, usually the minister would be responsible if the Parliament wanted to interrogate someone about a decision, or in terms of outputs and implementation of things. You know, a parliamentary committee, for example, might be able to get some department heads or public servants to talk to them about it. Whereas ministerial advisors occupy a sort of a liminal space in between those roles that's difficult to get into or get to the bottom of from time to time. And yet they make really significant decisions on behalf of ministers and for the executive. How currently, in all your respective roles, what mechanisms or how are you able to interrogate the role of ministerial advisors in that system of executive accountability, I guess, decision making?
Why don't you start, Deborah?
Well, the short answer to that question is I can't, unless it's a referral from Parliament itself, which there have been a few lately. So watch this space.
Did you want to say something, Sven?
Yes, thank you. For me, while ministerial advisors as a class, or indeed as individuals, are not considered agencies under, say, the FOI Act, information that they provide, for example, amongst themselves to a minister, to another ministerial office, or to the department, and so on, are called under FOI to the extent, of course, that they relate to the minister's responsibilities. And if they don't, you'd have to be even more deeply concerned. So in that regard, at least by the letter of the law, their actions can be made subject to scrutiny, to public scrutiny. In practice, of course, how effective that is, I think, is debatable because, well, firstly, the system relies on someone making an FOI request. Then the system relies on that request being suitably crafted and knowledgeable of the machinations of those officers and their relationships with departments to be able to be effective. And third, of course, it requires a decision to be made that actually accords with the FOI Act. So legally, yes. In practice, I think I certainly wouldn't be able to put my hand up and say it is working perfectly.
Well, there is no, I think this is a general proposition, there is no designed process in the operation of executive government that necessarily involves the functions of ministerial advisors. You have the role of the minister, you have the role of the department, you have the processes which the department is obliged to follow, but it's silent about ministerial advisors. So the only way to find out what contribution ministerial advisors have made to a decision is if you're able, as the Commission is able to do in private or in public, to actually examine the minister or the advisors to find out exactly what they've done. And it's only through those sorts of processes, and the Senate Select Committee was a glaring example of where they exercised coercive powers and established various things. It's only then you can find out what actual influence has been exerted. And I can do no better than refer people to the Koops inquiry and the many answers, or rather the many questions which could not be answered because the role of advisors, the knowledge of ministers simply didn't equip the inquiry to ascertain and obtain the answers that it was seeking.
Thank you very much. We have a few questions that have popped up in our chat here. First, it's from Colleen Lewis. She asks, as independent accountability institutions, and therefore one of the fundamental pillars of Victoria's liberal democratic political system, what are the greatest challenges you face in undertaking your citizens' watchdog role? I won't force one of you to answer first, but if you want to volunteer.
I'm happy to jump in on that one. It's a good question. Thank you, Colleen. I would say, and I do get this question occasionally, one of the greatest challenges to the role. And I might just start by saying it's sometimes funding, but that's not what I'm going to talk about. So I think we'll take it as a given that by and large, we managed to persuade year on year the governments to part with enough money to keep us going, as we, perhaps not quite as we hope, but at least enough to allow us to broadly discharge our functions. So it can sometimes be an issue, but that's not the one I'm inclined to reference. I think the one that's more pernicious than that actually is around release of information. So such things as cabinet and confidence privileges. And I would just give the very simple example from my public housing towers lockdown report that I was unable to get at who made the decision because I am not able to access cabinet and confidence material. I asked for it. And in fact, when I wrote to the Premier, I said, I notice you gave the Koops inquiry cabinet and confidence material. Would you extend the same to me? Answer, no. And that might have something to do with one inquiry having been set up by the government and the other not.
Well, if we're speaking about access to information, from my perspective, probably the biggest single blocker that I see, it's a pretty broad thing that I refer to as the secrecy reflex, where under either an informal application for information or in my case, more likely a formal FOI application, if there's anything controversial about it, if it's about a project that's controversial, if it's about an investment of money that's been questioned, if it's about an election commitment, those sorts of things, I see time and again, not universally, but mostly, I see a reflex of the decision maker in the agency to say, well, this is clearly controversial. How do I find the right exemption for it? And I'd love to turn that completely on its head, where a decision maker actually receives that request and says, I want to find a way to give access to it. Now, that sounds ridiculously naive, and do I ever think we'll get there? Well, I hope we do, and I've got to keep trying to get us there. But it's a big task. And where I think some of that comes from is this view that I sometimes have expressed that if information is made available about a project that is controversial, then this project, which in the minds of the decision maker is a really good thing for the people of whichever jurisdiction you're in, will be attacked, and therefore the people will miss out on this great project, which to me is quite scary, because it basically amounts to saying, look, we as the government, and again I'm talking about in any jurisdiction, have decided that this is a good thing to spend taxpayers' money on. Why so scared of scrutiny about whether the business case stacks up? Now, we all know that business cases can be made to say almost whatever you like, depending on whom you ask to write them and how you ask them to calibrate the assumptions and so on. But even so, is it really so weak that even the slightest scrutiny will bring it falling down? And occasionally I get asked, well, why are you against this project? Well, I'm not for or against any project. I'm there to make sure that there is a robust level of transparency and accountability, so that the people can actually be participants in their government, which they can only be with the right information, rather than passive participants who sit there and have things done to them. That shouldn't, in my opinion, be the nature of our democracy, and certainly Parliament's intention under the FOI Act is that is not how it is intended to work. So it's that secrecy reflex. Now, I'm pleased to say there are exceptions. I see plenty of cases that come before me where an agency has actually given something out, it's been embarrassing, it's been controversial, it's led to some headaches and so on. But the agency says, well, you know what, giving it out is the right thing to do, and then we will do our leadership job of explaining why we did it, or saying, yes, there are these risks that are disclosed by this document. Here is why we think it's worth taking those risks for some greater public benefit. That sort of leadership. That isn't threatened at all by transparency.
Well, I would just add that one of the occupational hazards that all three of us face is that we're at the mercy of the media. Our status, our credibility is in their hands, and you need go no further than the last 2 days of Victorian papers to see how, notwithstanding that my commission has been following a very carefully prescribed statutory process of giving persons in an operation whose names are mentioned in a draft report a copy of the report, the level of misunderstanding and in some cases mischief in what's then said about it in the public domain. So it's a good illustration of where we are ultimately at the mercy of the media.
Thank you. And Commissioner Redlich, we have a question from Ken Coghill, and it's probably quite generous of you to refer to the early release of that report as mischief, but There's probably other terms to describe that. But Ken has a question, to what extent, which is kind of running along those lines, pertinent to that topic, to what extent, if any, are the legal forms and status of political parties contributing to the problems and risks that you've outlined? And how could these be addressed and reformed without undermining democratic freedoms?
Well, I think Deborah and I have a particular interest in that question in our joint operation, in Operation Watts and the branch inquiry. And we will no doubt be proposing a range of reforms that will go some way towards addressing those issues. Would you like to say something about that, Deborah?
I think we should keep people hungry for more, in fact. So, look, clearly, what we're talking, and some of this is already on the public record. I mean, I have been very vocal going back to my first, my Red Shirts report back in 2018 about the need for a proper parliamentary integrity standards investigator to deal with this kind of thing. And yes, my view would, we obviously discuss that at the time, but should that include ministerial advisors? Absolutely, because where else would they sit? Where is the accountability layer otherwise? And we've heard so much about the increased importance of them within the parliament, within the processes of government.
We have another question from Ben Huff, which is addressed to Commissioner Redlich, but could equally apply to all of you as well. So I'll ask it jointly to all of you. In concert with the rise of ministerial advisors, could you reflect on transparency issues of executive government's increased reliance on private sector actors, both in the use of private consultancy firms, especially for the Big Four, for policy formation and costings, and the pitfalls of private-public partnerships and outsourcing, such as commercial and confidence?
Look, for my own part, I'm not sure that I can add much to what fell from Coldrake in his interim report. His observation that in the short time that he's been looking at the questions that he's commissioned to assess, it's evident in the Queensland example what a substantial level of recourse there has been to private consultants, and we've known for perhaps the best part, at least of a decade, that's a trend that's been occurring within state governments. I think I would be loath to express any view about the extent to which it's value added, as distinct from whether or not those same roles could have been effectively performed by experienced officers within the public service. I would be loath to comment further on that at this stage.
I'm happy to give some examples from the FOI and transparency context, because the FOI Act certainly does contemplate this and deal with it, I think, on the whole, fairly well. So there is an exemption from disclosure, and obviously I'll paraphrase here, under FOI where the disclosure would involve revealing commercial, financial, etc. information about a private business, and where disclosure would have an unreasonable negative effect on those affairs. So that's actually a pretty high bar to get over. So, but when I mentioned earlier the secrecy reflex, that reflex is alive and well in this space. So where you have an FOI application that seeks access to something that may have been prepared by a private sector consultant, which of course happens all the time, then often we see the first instinct is to say, well, it's so-called commercial in confidence, although that phrase does not actually appear in the FOI. And of course, once I see the report, because I do have the power to see it, the report is clearly plastered with commercial in confidence, watermarks, footers, headers, all of those sorts of things, and a big disclaimer saying this is only prepared for person X or department Y. I'm at the point where I almost don't even see those letters anymore, because they have very little meaning. However, there is an exemption that I have to faithfully consider. Often the argument is made, the agency consults with the consultant or the expert who prepared the report, and that expert or consultant expresses a strong view that this should not be disclosed. Well, yes, that's fine, but that's not the test in the Act. And so quite often the argument then upon pressing is being made, well, if we release this report, that will harm this third-party operator's commercial affairs. And then next time we go out to the market, we might not get any responses. Now, that last part, I think, is very easy to dismiss, because in my experience, those sorts of providers will make their decision on whether to bid for something based on whether it is financially in their interest to do so. And that's how the market operates. But in terms of the test in the FOI Act of saying there has to be, for it to be exempt, there has to be an unreasonable negative impact of disclosure, not any negative impact, an unreasonably negative impact. That allows me to take into consideration the fact that if disclosure of this document would have some potentially strong positive impact on transparency and government accountability, then that is a countervailing factor against the negativity of the impact on that business's disclosure. And that is part of, for me, of weighing up the process of whether that disclosure or the negative impact is unreasonable. And it's actually pretty rare for me to find that. But also, in many cases, of course, you can release a lot of the document without having any negative impact on that third-party provider, and maybe hold back some small part that is their genuinely state-of-the-art mechanism or state-of-the-art business process that they've brought to bear on this situation. Okay, keep those few paragraphs and release the other 400 pages. So again, it brings me back to that secrecy reflex. But so the Act itself, I think, is pretty strong in that regard. It allows good decisions to be made. It's the culture of the decision makers that is the bigger problem.
I think, just very briefly from my perspective, this is a huge subject. The impact of public-private partnerships, the increased outsourcing of government functions is massive, and one that I couldn't possibly do justice to. But I think just the one small contribution I would make to this debate is that it's not all doom and gloom as far as accountability is concerned, because one of the positive things that has happened, for example, in my office and similarly to the Auditor General, before me, is our ability to pursue matters when privately funded or private organisations are carrying out a publicly funded responsibility. So the accountability system is able to extend its reach more than it could into some of these areas, and that is obviously a good thing with increased outsourcing. But huge policy questions and significant impact, much of which I think many of us would feel is profoundly negative and does not carry the level of accountability and transparency that we would all wish to see.
Okay, well, I have another question. It's more of we're heading to the level of abstraction a bit with my question. It's sort of a one way back in the day when the IBAC was first established. I was an executive officer for the IBAC committee in those days, and was intrigued in what an independent officer of the Parliament might mean when having a look at, and I introduced you all as independent officers of the Parliament. Under all of your acts, it specifically says that there are no implied functions, powers, rights, or immunities or obligations arising from you all being independent officers of Parliament in Victoria. But on the flip side of the coin, it also says that the Parliament itself has no implied powers over you as independent officers of the Parliament. Can I ask, what does it mean to you in your various roles? What does being an independent member, independent officer of the Parliament mean? I told you it was going to be much more abstract.
Well, you would come as a surprise, I suspect, Vaughn, that each of us, I'm sure, have had to engage with our relevant ministers from time to time exploring that very question, particularly in the area of budgetary independence, a very topical question at the moment. There's unfortunately a lot of wriggle room in terms of what the government of the day can say about what that independence actually entails. There is no simple answer to the question. when it suits, as perhaps yesterday might have illustrated, if any of you watched the Premier's doorstop conversation, independence is critical to the Integrity Commission's role. On another occasion, it won't count for much at all.
I think there is much to be said on this subject as well, but I guess the one thing that I see as the most significant element of my independence is my ability to speak directly to Parliament and thereby to the people. So I don't provide my report, none of us do, we don't provide our reports to ministers, they can't sit on them. We speak directly to Parliament, we table directly in Parliament, and when we table in Parliament, we are therefore speaking to everyone. And that for me sort of encapsulates what it is to be an independent officer of Parliament.
Yeah, I don't really think I can add anything to that. I agree with all of those sentiments strongly. Yeah.
All right. Well, thank you for indulging me. We have one final question from Colleen Lewis again, who thank you for all the excellent work you do for the Victorian people. You've outlined the need for legislative change to enhance accountability and transparency. But Colleen asks, will this happen given that it's CSER that has the power to legislate the accountability processes that will impact on CSER?
Well, you are so right, and this is something that the IBAC Commissioner and I discuss on a very regular basis, and particularly at the moment. But I believe in the people here. I believe in the public, and I think our role as integrity officers is also to persuade you and to persuade the people of Victoria that these things matter to them, and that these things matter enough for them to persuade their elected representatives to support them and to develop policies that support them. We've seen this in Canberra around the Commonwealth Integrity Commission. We've had people saying that none of that matters. Well, actually, we're seeing that it is mattering. Well, we'll find out how much it matters. But it has become, when something becomes an election issue, then it might happen. So all we can do as independent officers of Parliament with investigative roles is to present what we think are the reforms that are necessary. We can't implement them, but we can monitor them. We can make a hell of a fuss, and we can invite others to do the same. So I would encourage everybody who believes in transparency and integrity and accountability to go on fighting the good fight and doing your good work to make sure that people don't get away with reducing it or suppressing it.
I will see, Deborah. I'm optimistic that when reports are published, and we have numerous critical reports that have to find their way to Parliament and then into the public domain, that the cogency of some of those reports will ensure that the government of the day, whatever its political persuasion, will have the appetite to implement some of those reforms. Each of us goes forward in our discrete areas of work, I think with the belief that we can make a difference in terms of government's thinking about the need for reforms. I'm confident about that.
And if I can just add something to that on the note of optimism, which I think has been mentioned by both Deborah and Robert, is that I also have a level of confidence in individual ministers and elected members of Parliament, in the sense that not across the board, but I think in any Parliament and in any government, you have a number of those individuals who really see the importance of this, not just as a political tool or a bargaining tool, or even not just to hold a future government to account when they might find themselves in opposition, although I often find that can be quite a persuasive thing as well. But I think some of them really get this as an important thing to leave for future generations, that when you look around the world, you look at other countries, you look at stronger and weaker democracies and non-democracies, I think there is a number of elected individuals, some of them in positions of considerable power, who actually get that this stuff matters and who want to leave this as part of the real machinery and foundation of our system of governance for the benefit of future generations. Again, that sounds perhaps a little bit Pollyanna-ish. I wouldn't go so far as to say that that's a majority, but there are some. And I think when those individuals find their moment and utilize the opportunity to do so, they're also allies in making this sort of thing happen. The difficulty for us, of course, is it would be completely for us to engage with any of them directly, given that we are politically independent. But seeing this, especially happening in other jurisdictions, you do see signs where once in a while something like that comes to the fore and some really good change for future generations gets made. And I think that that does happen from time to time, and that gives me some confidence as well.
Okay, well, that brings us around to 12:30. On behalf of the ASPG, I really do thank you for making the time for us. I know you all have many other duties to attend to, but it's really been a fascinating discussion that you've allowed us to have with you, and so very much appreciated. And in particular, I guess, for those of us with COVID to have still attended virtually. It's been fantastic. I'm sure if we were live, there would have been a massive round of applause on behalf of all of our members. So I'll just announce now that we have a half-hour break. We'll be back at 1 o'clock for the remainder of the afternoon's proceedings. But thank you, everybody, and hopefully we'll see you in person at some future date. Thank you.
Thanks, Vaughn.
Thank you all.